Our webinar is Conducting Depositions Online, what you need to know to execute the process successfully and legally. My name is Joyce Olette, and I'm your host for this session. I have a few housekeeping items to start with. All of you have been put on mute, and that mute will stay on throughout this webinar. But if you do have questions, put the questions in the Q&A. The Q&A can be found on the Zoom taskbar at the top or the bottom of your screen. We'll answer as many questions as possible throughout this session, and at the end, time permitting, we'll answer them live. Also, at the end of this session, I'll provide you with an email address for you to send any unanswered questions to. Alrighty, let's get started. I'm really pleased to introduce our speakers for today's session. Avi Stadler is General Counsel of Esquire. Prior to joining Esquire in 2014, he was a practicing litigator for over 20 years and partner at Sutherland, Asbill, and Brennan in Atlanta. And Peter Hare is our Director of Product Marketing at Esquire, where he focuses on the design and development of emerging technology-enabled legal support services. So I'm going to turn it over to Avi to take us through the agenda and get things started. Avi?
Thanks, Joyce. Hi, everybody. My name's Avi Stadler. I'm the General Counsel of Esquire, as Joyce said. I'm going to walk us through the agenda and kind of walk through what we're going to talk about. We're going to start by understanding the whys. And that's always important to me to understand why. I'm going to give some background that a number of us or all of us are familiar with at this point with regard to the business environment, the legal environment, and the court environment concerning how the court and everyone is adjusting to this new abnormal that we'll talk about. We'll talk about the rules governing remote depositions. And the reason why we're going to talk about all of this is that you can enable you to have conversations with opposing counsel, witnesses, clients, and courts as to the necessity of proceeding remotely with your cases. So that's very important to understand the why before we talk about the how. Once we're done with the why and we talk about the rules, we're going to talk about specifics, things to think about before, the day of, during, and after the proceeding. We're going to talk a little bit about information security, and then we'll circle back with some next steps. So that's what we're going to talk about today. I'm going to start by talking about litigating in normal. And I want to start by saying that we are living in, people are calling this the new normal. This isn't normal by any stretch of the imagination. This is all very abnormal, very strange for all of us to be working through this environment. Before I get started though, I would like to talk about two words. I'll talk about two words that are very important to me right now. They are grace and empathy. Right now, because of what is happening, we should extend to others as much grace as possible. That we should, whether that's opposing counsel, whether that's people in your family, whether that's coworkers or whatever, this has just been a very challenging and difficult time. And for many of us, this has been lasting for many weeks. So we should, as we go through, as litigators, we are often sharp-elbowed and we have this obligation to zealously represent our clients, but we can do that and discharge our professional obligations by using grace. And the other word is empathy. We need to be empathetic to those that we are working with. We don't know if opposing counsel is dealing with a sickness themselves or sickness in their family. We don't know what's going on with everybody. So let's be empathetic and take a deep breath and with respect and courtesy, even more so than we normally do. Let's talk about the abnormal time. We are all living through a time in which commercial activity is severely restricted. There is this division that has come up between essential and non-essential businesses and what can and cannot go forward. And even as things begin to thaw and the economy opens up some, there are still fairly strict restrictions about how we conduct our business, and we'll talk about a lot of those restrictions. Social distancing, even in the beginning to reopen economy, is paramount. I've been spent all morning looking at CDC regulations about social distancing and how important it still is, and that everybody still talks about how important it is to make sure we do that. And many businesses are still functioning under a mandatory work from home. So this is this is the business environment in which we work right now, and it's very important that we stay right there in that business environment and understand that as we go forward. In light of all of that, we're going to talk about what's at stake. And what's at stake right now is pretty significant. I have reviewed and continue to review, in fact, was just reviewing Texas's latest order about the court administration. And one thing that you read about, over and over and over again is the exacerbation and the worry of court that they are exacerbating the court backlogs. That when you look at these orders from the courts are already strained pre-COVID. Now that things have been on hold or barely proceeding for the last few weeks, there's a concern that court backlogs will continue to be exacerbated. And so we, as professionals in the industry of litigation, need to work as hard as possible to continue litigating, even though it's not litigating as normal. We also have to protect our clients' cases. We need to make sure that cases are moving forward and that cases will be ready to move forward once courts are back open and we can go back into court. In addition, what's at stake is the firm and attorney business continuity. Every single day there's a new news report out about how a law firm, one of the big law firms, is cutting salaries or furloughing workers and other things. And if we're not litigating, if we're not able to bill our clients, if we're not able to move our cases closer to settlement, then we're not getting paid. And the law firm itself is struggling. So we need to be able to move our business forward, our cases forward, and we need to protect court backlogs. And as we know, there are essential cases that just have to be heard right now. There are temporary restraining order cases, there are constitutional cases that must go forward, and we need to be able to adapt and get those cases to move forward. And finally, the most important thing that's at stake is the health and safety of all members of the court system. And this was highlighted recently. At the beginning of March, there was a trial in Dougherty County, which is southwest Georgia. It's Albany. There was a murder trial going on, and one of the jurors had COVID. And 23 members of that court community were struck with COVID, and it spread like wildfire, as this disease does. And a judge ended up dying from that. So again, that's just a stark reality of what we're dealing with at this time. So there is a lot at stake, and why we as a community need to be able, a litigation community, need to be able to move things forward. We don't have the option of sitting on the sideline. Our practice typically requires, and has typically required in the past, in-person contact at depositions, mediations, court proceedings, and we are working very hard to try to adjust to keep our cases on track. And we're going to see, and we have started to see already, that there is a spike in coronavirus-related cases that are coming up. A recent article talked about hundreds of new class actions that have been filed. We're seeing a spike in employment cases related to what's going on with COVID. There are going to be your garden variety insurance claims that are going to relate to force majeure clause, businesses arguing about that. You're going to have real estate actions with relating to businesses that are not paying their rent. You have data privacy issues. Since we're all sitting here at home working from home very often, there are additional data privacy issues, and something that we as lawyers need to really consider as we are working from home and transmitting client-related data back and forth to ensure that we're doing so safely and securely. In fact, the Pennsylvania bar recently issued, the Supreme Court issued a warning to its members to make sure they are safeguarding those things. So we're going to see additional cases coming forward in that area. So there we are, and then you'll have your typical recessionary litigation. I mean, every time there's been a recession, litigation spikes. I was reading a study done by McKinsey on this topic, and it is a pattern that has happened over the last 20 years. And I can talk about it from experience because I worked in one of those counter-cyclical litigation areas of securities litigation, and within a year of a recession, we were bombarded with new securities cases, class actions, and individual lawsuits. So we are going to see a spike in litigation. And because of that, and because of this lull that we've been in the last 8 weeks, courts are very, very concerned about this backlog. And we need to help those courts as much as possible. We need to balance a lot of things. The need to move things forward remotely requires a lot more heavy lifting than just all of us being in a, not a lot more heavy lifting, but a lot more coordination as you are getting things together. You have to coordinate the clients, the witnesses, the parties' schedules, and also ensure that everyone has the technology and has tested everything available for them. There are state and local guidelines restricting our commercial activity, whether we can even be in person. I was just reading today, this week, the Texas court system issued a guidance on pre and post June 1st activity, on what is essential and what is not, stressing very strongly that we need to move forward with remote proceedings, including depositions. So that is again what we are going to be living in for the foreseeable future. As you can see here, there are going to be parties that are going to want the delays. They're going to want to push things forward. And so the key here is being able to have the kind of conversations and discussing the factors that we will be discussing and are discussing to make sure that we can balance and move forward. There was a great article in the New York Law Journal. It's now, it feels ancient because it was, you know, a month and some change ago, almost 2 months ago, but some pretty practical tips about how to keep your cases moving forward. And before I get into that article, I will talk about courts are starting to issue opinions and orders addressing the issue of parties delaying cases and delaying depositions and delaying discovery because of the pandemic. And as I thought would happen, they are not very happy about it. A recent Southern District of California case dealt with a party saying that they could not have depositions because they could not meet in person. The court said very clearly and denied the request for a stay, saying very clearly that attorneys are adapting, including conducting depositions remotely. And there are numerous training opportunities around to assist with technology to permit lawyers to move their cases forward. And the court was not having any of the delays. They would not allow for a delay. Similarly, the Eastern District of Louisiana order authorizing specifically remote depositions and saying that the parties needed to move forward with discovery during this period, that it was not a hardship, and that discovery should continue. These two court cases highlight some of the tips that that is in this article and that we would talk about. While it's okay and it's showing empathy and grace to give reasonable extensions, extending things indefinitely is not a good idea. People can move forward with their cases. When you're opposing counsel or witness or client or opposing when you have an objection to moving forward, get that in writing. Require opposing counsel to explain why a deposition can't be held, and don't be afraid, as these two courts have shown, to go to the court and say, we want an order to order the other side to go ahead and have these remote depositions. They are amenable to that, and as I will talk about, most of the orders that are coming out from the Supreme Courts of the various states and jurisdictions specifically ask parties to move forward using remote means. And finally, don't let perfect be the enemy of good, meaning in-person depositions would be perfect. That's the way we've always done things. It is the way that we are most comfortable doing them, and is the way that we as litigators would feel best about going forward. But the technology available in video conferencing is good. It allows you to do everything you could do, almost everything you could do in an in-person deposition through video conferencing. You can share exhibits, you can mark up exhibits, you can examine witnesses, you can get a video if you want a video of the deposition. You will get a transcript from that deposition. It is a good option to use to keep things going forward and allow you to continue your practice, to allow your cases to be moved forward, to help alleviate the court backlog that exists, and to deal with important issues that need to happen. So these are some ideas and thoughts to have some conversations with opposing counsel and others. The fact of the matter is, remote technology is playing a larger role in business. We are seeing the Supreme Court of the United States having oral arguments via telephonic hearing. You are seeing the Georgia Supreme Court, for instance, do all of their arguments via Zoom, where you have all of the justices on the screen. You even have the timer countdown on the screen, and you have the people who are arguing on the screen, and it is going smoothly and is working fine. You have hearings being held. You have some jurisdictions that are considering having Zoom trials to go forward. You even have Saturday Night Live doing their broadcasts using Zoom technology. So it is here to stay, and it is here as an option for all of us to continue working during this time period. Let's transition. We just talked about the whys, the conversations that you can have, some discussion points you can have to make sure that you understand why we want to do this. Now let's talk about the rules governing remote proceedings. The fact is, states across the country have issued and are continuing to issue emergency orders that relax legal requirements and that specifically encourage the use of video conferencing as a way to conduct legal business. To, one, help check the spread of coronavirus, but two, to make sure that cases can move forward and there will not be a glut or a backlog when things start returning to normal. So those exist. I'm going to show you an example of one that was recently issued by the Supreme Court of Georgia. Most states have issued something very similar to this. In the first paragraph, or one of the first paragraphs, it specifically talks about the backlogs when the judicial emergency ends. So that is something that you would always want to talk about if you ever have to go to a court to get remote depositions, or you can talk to your opposing counsel as a why. Second, and this is I think important to another point that I was talking about, the Supreme Court of Georgia, Chief Justice Melton specifically talks about the obligations that we have as lawyers of professionalism. And I was lucky enough to hear Chief Justice Melton speak a few weeks ago about this particular order. And what he said about this professionalism provision, it is the, quote, "don't be a jerk" provision. And it's more than just not being a jerk to your opposing counsel. He specifically said that the reason why he included this in here is that he wants lawyers not to panic at innovation, that he wants lawyers to be amenable to and work with opposing counsel to move things forward, to not object to the remote proceedings, and to honor the fact that we've got to find a new way to do business during this time period and encouraging that business. And I think that's an important theme throughout all of this. Let's turn to the actual federal rules of civil procedure to talk about how one can continue to do business in this time period. I'm going to talk about the federal rules because, as many of you know, the federal rules, many of the state rules out there are modeled after the federal rules. So we're going to use the federal rules as a guideline and then specifically talk about that. Rule 29 is the rule that allows stipulations about discovery procedure. It's not a rule that we spend a lot of time talking about in law school or that we think about very often, but it's very important in this instance because this rule allows the parties to stipulate that the deposition may be taken at any time or place before any person on any notice and in the manner specified in the notice, which means that you can specify that it be done by video conference technology, that it be done remotely, and other things. And then if you look at the next rule, which is Rule 30, and this is a rule we all are familiar with because of typically 30b-6 depositions, but if you look at 30b-4, it specifically says the parties may stipulate that a deposition may be taken by remote means. So it specifically addresses remote depositions and allows it to happen. And if you look at the commentary to the 1980 revisions of that rule, it specifically states that it eliminates the necessity of the presence of one whose only function is to administer the oath. In other words, you don't have to have a notary or a court reporter sitting next to the witness in person to administer the oath, that you can administer the oath remotely by remote means, which is very important because that is one of the stumbling blocks in some situations for having a fully remote deposition where everybody's in a different place. The nice thing is, in this time period, the courts have been very quick to act to allow for flexibility to conduct remote proceedings. Remote swearing of witnesses and remote testimony is now permitted in every state. There are special orders in a number of states that specifically permit it. In addition, if you look at the Rule 29 equivalent and the permission there, you're allowed to do it. I'm going to highlight one particular of these orders just because Florida is such an important, this order was such an important order. In Florida, there was an Attorney General opinion that was issued, I believe, in 1992 that cast doubt and sort of prohibited, without further judicial action, the practice of doing remote swear-in of a witness. In other words, it required the physical presence of the court reporter with the witness. When the COVID situation became clear, states began to relax and send emergency orders out there. Esquire actually worked with, I specifically worked with a law firm, and we went to the Florida Supreme Court and we said, hey, we need the litigants in Florida need some relief here. We need the ability to because of your backlogs, because of all the things that you have talked about, Florida Supreme Court, we need the ability to swear witnesses in remotely. And lo and behold, a couple days later, 48 hours later, the Supreme Court of Florida issued their emergency order specifically permitting, as you can see here, and you can pull the order, specifically permitting oaths to be delivered by video conference, meaning that you can have a fully remote deposition in Florida. That current deadline is May 29th. Everyone is hoping that deadline will continue to be to move forward. But again, another example of how courts are acting quickly and in support of remote deposition technology. We've offered up here a couple of stipulations that you may consider. Again, this is not legal advice, it's simply an example. There really isn't a ton of magic here. This first stipulation is if you are proceeding under a Rule 29 equivalent, whether that's the federal rules or an equivalent state rule that many have. It specifically says that parties will be stipulating that it will be remote and that the oath will be delivered remotely, and that everyone agrees that the witness who the witness is supposed to be. The second stipulation would be particularly important in those states that require in-person oaths. Florida, Texas, and Connecticut are three of those states that had previously done that, but have issued Supreme Court or other orders that permit it. Sometimes governors are the ones that are issuing the relaxation of notary requirements. You just need to find it in the state, but they're available. And this is a stipulation that's essentially the same as the prior one, but it specifically references the court order. So these are some ways that you can stipulate. The fact of the matter is remote depositions actually aren't new. I've been practicing for quite some time now. I have taken telephonic depositions since the beginning of my practice. They're awful. I hated taking telephonic depositions. It's very hard to connect with the witness. It's hard to deal with exhibits. It's hard to deal with everything, but it isn't new. They are permitted by a lot of states and a lot of jurisdictions. But the technology that exists now make it just so much easier. It's like what we're doing now. You know, you guys can see me. You can see the screen that we're sharing, just as if we were talking about an exhibit. And it's an easy way to have the closest in-person feel that you can have. The other benefit of remote depositions, and I think a benefit that we will continue to see remote depositions even after the COVID situation resolves itself, is that it is cheaper because parties don't have to travel. It's more convenient because you can do it from anywhere where you have an internet connection, and you can save a ton of money on exhibits and shipping. And then the last piece that I always like about the whole the remote deposition is that you can increase the size of your trial team and you can increase collaboration. So if you have a client that is in, you know, another state, they can participate remotely and can help you during that deposition if needed. So remote depositions aren't new, but they're great. And I think the more that people get used to it, the better off they'll be. The one thing I will say, and this is sort of a catchy saying, but it takes more than a webcam and an internet connection to safely and securely conduct a deposition. I mean, you need to work with a good court reporting company that can help you with this. You need a good court reporter who's comfortable with this. You also need security in place, and you need a platform to do it. So there's a lot of things that we're going to talk about right now to help you think through what you need and some things that you might not have thought about while conducting those depositions. And with that, I'm going to turn it over to Peter, who's going to walk through some of the logistics.
Thanks, Avi. I appreciate it. I'm going to review the details associated with holding a remote deposition when the court reporter is not with the witness. The process is very similar to a proceeding where the court reporter is with the witness and one or more parties are attending remotely. So you may be familiar with that. You might have had depositions like that. However, a deposition with all parties remote, including the reporter, requires more preparation and an attention to detail you may not have thought about. So I will step through the different stages of planning and preparation and execution and provide best practices you and the court reporting agency should follow to ensure a smooth proceeding. So what do I mean when I talk about remote services? First, there is the somewhat traditional remote deposition service. One or more attendees are remote and the court reporter is with the witness. Up until March, this was the most common form of remote services. Then there is the remote court reporter service, the remote deposition service, but the reporter is also apart from the witness. Add on any of the following remote options as needed: real-time reporting, remote videography, where a videographer remotely records the proceeding using the video conference software, the remote interpreter, and finally, the delivery of the end product via secure online repository so that you can access the transcript, exhibits, and video from home. What makes the remote court reporter service different from the typical remote deposition? Really, at its simplest, it comes down to this: the court reporter is not in the same location as the witness. And while in some states this has been available for years, with the current pandemic, this service now means everyone is remote. And with that change, the processes required to prepare for and hold the proceeding must change. What does this change look like? Let's start with the court reporter and their role. In short, the role of the court reporter should remain focused on the core reason you need them: to take the record. The reporter continues to swear in the deponent, take down the record, perform readbacks as requested, control the proceeding, and receive the exhibits before or after the proceeding, though of course electronically now. There are some functions, however, that should not be added to the court reporter's responsibilities. Let's look at them. First, they should not be asked to download and share exhibits during the proceeding. They should stay focused on taking the record. And they should not be considered the tech support for technology-based questions. They should be able to hand off any technical issues to the agency. While it seems natural to add these responsibilities to the court reporter, these actions will undercut the ability of the reporter to perform their core responsibility: take down the record verbatim. So while the role of the court reporter remains traditional, the way they carry out their role remotely is anything but traditional. Things have changed. With all parties, including the witness in different location, your remote reporter should be trained to work in this new way. So ask these questions before you commit to an agency. What kind of remote reporter training did the court reporter receive from their court reporting agency? Do they have a clear idea of their roles and responsibilities as a remote reporter so that they can focus? Who is available to support your court reporter before, during, and after the deposition so that they can focus on the proceeding? How long has the agency been doing remote reporting? Did they just introduce this in response to COVID-19? Or can they explain their experience and go into detail? With all parties and documents shared online and transmitted across the internet, What is the agency's infrastructure and data handling procedures? How are they secure? Is their staff trained in document security, and can they discuss it with you? As we will discuss next, the secret of a good remote proceeding is preparation. Because success lies in preparation. Preparation requires support beginning and during the deposition. First things first, make sure all parties, especially the witness, have the correct technology to participate in the remote proceeding. Checking first with the witness is important because we are certain attorneys have the technology they need, but it isn't a sure thing that witnesses do. And under current conditions, a court reporter cannot bring an additional computer or iPad to the witness. So what technology is needed? You need a computing device, a Windows computer or a Mac, an iPad, an Android tablet, good speakers, a good microphone. Most critical is the internet bandwidth. We recommend you plug your computer into your router if possible, but if not, then prepare your home office for a wireless deposition. We will discuss this in more detail shortly. In short, approach this as if you were preparing to record this deposition for trial. How should the attorney and team prepare for a remote deposition? First, ask others on your team if they have the equipment and bandwidth required. Next, include language in the notice disclosing the proceeding methodology. State that this will be a video conference, that the witness will be sworn in remotely, and add any stipulations if necessary. Be sure you have prepared your exhibits to be shared electronically. Determine who on the team will share the documents and make sure that they have them in one easy-to-access folder on their computer's local drive or web folder, and not on a network or document management system. As to who should share the exhibits, that is your decision. I met with one large law firm in Florida who decided to assign document handling to the paralegals. This allows the attentions to focus on the deposition. Finally, and very importantly, use the same equipment you tested on with your agency. Last-minute switches of equipment or location are as risky as they sound. Avi?
Thanks, Peter. A little bit about witness preparation, and I'm going to specifically talk about witness preparation if you are preparing a witness for a remote deposition. I've been preparing witnesses for many years. Much of the guidance that you would typically give a witness is the same, but there are some things that are different. And the first is just what Peter said. You want to confirm and test the witness's technology in advance of the proceeding. You want to make sure the witness is comfortable using it, and you don't want to switch the device that they're using the day of the proceeding. So make sure your witness understands how to use the technology. Go ahead and practice with it and allow the witness to fool around with it. If in your jurisdiction there is no attorney-client privilege issue, go ahead and video it if you can and work through it so that the witness can actually see how they appear on screen, because it is a different feeling. Folks tend to be a little more casual with the way that they act on a video, and they need to understand that this is a legal proceeding and they need to act accordingly. Make sure that they are positioned appropriately in the window. They can see that they're wearing whatever the appropriate attire, professional attire. Make sure they're in a quiet, safe, secure, nondescript place. There are no devices around that are doing any recording, that they turn off all of their distractions and other things so they can focus on what's going on. And make sure, again, they're on video during any dress rehearsal that you do. The other thing that is important in any deposition is to make sure your witness listens very carefully to the question and answers only the question asked. The way that I've typically helped my witnesses understand that is to make sure that they listen carefully, that they pause before answering, and then they answer. This is even more important in a video deposition, just because there may be some lag and there may be some issues with people jumping in and people talking over each other, to make sure that there definitely is a pause before they answer. Listen, understand, pause, and answer the question. And then I would also set an expectation that a video conferencing deposition will take a little longer than a normal deposition, in-person deposition. And the reason is that there are technology issues that arise. There's people talking to each other. There's people getting back from breaks late. Just make sure that everyone understands that. Now I want to talk about some rules if you are taking the deposition, some things to think about and some rules that you could potentially get in place in advance to make sure that there are no shenanigans going on during your deposition. Make sure the witness that when you are examining the witness, that the witness is appropriately in the screen so that you can see the witness. In addition, it's good if you can see their hands, because if you can see their hands, you can tell if they are writing things down or if they're sending texts or emails using a device. Have them on the record acknowledge that they agree to not send messages, use devices, that they've turned off all cell phones and iPads and other things in the room. They've identified any communication devices that are available in the room. If there is an Amazon device or a Google device in the room, make sure they identify that so that you know it's there. Make sure that they on the record confirm that no one else is in the room. We had someone ask in one of these if it was you could ask a witness to turn the camera around to ensure that there is no one in the room. There's no reason you can't do that. So make sure there's no one in the room, and make sure the witness agrees that if anybody does come into the room, they will identify them and put that person on camera. Make the witness, again, agree not to communicate with anyone during the deposition so that they're not sending messages to get answers or to be coached by anyone during the deposition. And then also, an important thing for you to figure out before the deposition is to make sure that you have a method by which you can communicate with your team or your client during the deposition. So Zoom that we're on right now allows you to turn off the video and mute yourself so that you can have conversations in whatever manner you want. Zoom also has breakout rooms, so you could set up in advance a breakout room where only you and your team can conversations. But whatever you do, whatever the right thing for you and your particular situation, make sure that you have a way to communicate confidentially and easily during the deposition. Exhibits. Peter's going to talk a little bit more about the technology related to exhibits, but I wanted to talk about a little bit about the strategy. As I said, I used to do telephonic depositions, and when you did telephonic depositions, really you only had one choice back in the day, and that was to go ahead and mail all the exhibits you were going to use for the deposition to the witness, which took out any element of surprise, which allowed the witness to take a look at that ahead of time. And to prepare for those particular documents. And that would have been the same if you emailed the documents out in advance before the deposition. If the element of surprise is important and you want to recreate what it feels like to actually be in a deposition room, technology exists now where you can share the exhibits real time, mark them, and admit them. And that allows you to have the same look and feel and continue to have the same strategy that you would typically use in an in-person deposition. And those, I think, that would be the way I would want to go if I were doing a deposition these days. It's very similar to what we're doing again right now, is that Joyce is manning the PowerPoint and you're all looking at the screen and seeing it. And if I wanted to question someone on that particular exhibit, I can enter the exhibit, mark it, and we can talk about it. And Peter will talk about some other features that are available. But thinking ahead of time about how you're going to deal with those exhibits is incredibly important. Practicing ahead of time on how you're going to handle those exhibits is incredibly important so that you feel comfortable. But the nice thing is it is very easy to use and it will work very nicely. Peter?
Thank you. Appreciate that. Exhibit preparation is perhaps the most important part of this process, as Avi said. You have several options to consider. At a minimum, if opposing counsel will also have exhibits, agree on a numbering scheme to simplify the process. When it comes to marking the exhibits, decide when they should be marked and who should mark them. If you're in the position to pre-mark them, there are several ways you can self-stamp. Adobe Acrobat Reader has a free plugin that enables you to use their comment feature to stamp your exhibits. Exhibitstickers.com also has a very nice automated way of numbering exhibits for under $200, or a free version that has a more manual approach. But pre-marking may not be the way you want to go in some situations. The court reporter or agency should also be able to mark the exhibits once they have been submitted. Discuss with your court reporting agency how they handle stamping. Do they require you to do it, or do they and the court reporter also have the ability to mark the exhibits? Get that straightened out early so that you can prepare. When it is time to submit the electronic exhibits, it also helps to include the exhibit number in the file name. This makes it easier to find each exhibit during the deposition, and a simple exhibit file name doesn't reveal what is in the document. We'll discuss exhibit submission in a few minutes. All right, so you've done the pre-check. Your team and witness has the technology they need. You've gotten that information, and you've decided on who will do the exhibit sharing and marking. So what is the role of the court reporting agency as you prepare for the deposition, especially if you're new at this? First, even though you have asked the right questions of the participants you control, the agency should do a test to validate the hardware and connections of all parties at least 24 hours before the proceeding. Each test should take no more than a few minutes and can be done one party at a time. The purpose of the test is to make sure that the equipment works correctly, that the webcam works and the party can hear and speak clearly, the bandwidth is good, and the picture and sound is smooth and clear. Do you want real time, a remote videographer or remote interpreter? The agency should also confirm those optional proceeding services, because while this information was probably relayed during the initial request, it never hurts to double check to make sure nothing slips through the cracks. As I discussed earlier, your agency should discuss with you how you will share your exhibits during the proceeding, how you want them marked, and how you will submit them to the reporter. Understand what the agency will do to ensure you receive the training you need. The day of the proceeding, you are prepared. Now, let's review the final preparations. Enter the virtual room at least 20 minutes before the start time of the proceeding so that you can make sure nothing has changed. Use the video conference's audio test to make sure you can hear and be heard. Make sure your webcam is working and that you can see and be seen. Make sure your video stream is smooth, meaning you have a healthy bandwidth. We recommend a minimum of 5 megabytes per second. To find out what your bandwidth actually is on the day of the proceeding, go to www.speedtest.net. Finally, make sure all unnecessary applications are closed so that your computer's system resources are freed up for video processing. But this is about more than just technology. The environment check is something you probably didn't think about when the deposition was in your office or at the agency. But at home, a detailed examination of the environment becomes critical. Check these potential issues before you enter the proceeding and when you first join. Before you enter, make sure there is no unnecessary use of bandwidth in your location, including streaming video services like Netflix or Hulu, or resource-intensive online games. Make sure your smart speaker assistant is turned off or down. Finally, make sure your cell phone is off. Any texting applications are set to do not disturb, the door is closed if possible, and the background noise is down or gone. Once you enter the session, make sure your face is positioned correctly for the proceeding with an uncluttered background, good lighting to show your face to the court reporter and others. Make sure you are facing the camera, the microphone is near your mouth, and ask others if you can be clearly heard. Make sure you are dressed for a deposition and not dressed for home. Remember, you are all together in the same room in a professional capacity. You should also confirm the exhibits are ready to present. The presenter's exhibit folder is open for fast access. The technology check is completed. The environment check is completed. Also confirm that the witness's environment check is completed, recalling what Avi said earlier about others in the room and any communications technology at hand being disclosed for the record. This is important. All parties should be on camera during the deposition, as if they were in the room. This makes it easier for the court reporter to identify each of the parties for the record. It will also help them identify the speaker. The agency should also do their final check. They should make sure everyone who was invited has signed on and can be clearly seen. They should also answer any last-minute questions and remain available on call to the court reporter as technical support. The proceedings begun. What are some best practices and what should the court reporter be doing? There are best practices when it comes to remote audio and video. First, hold down the background noise by muting yourself if you do not have a speaking role. All video conference software has a mute button. Turn the video on and keep it on. You can see the reporter and the videographer on the screen if there is a videographer. Make sure they can see you as well. If you have trouble hearing or being heard, use the test application most video conference software programs have to see if it is you or if you need to reconnect or switch to another audio input device, either the computer or the phone. What should you expect from the court reporter during the deposition? You will recognize all of these bullets since these items have always been their primary responsibility. They initiate the proceeding, starting the record. They request counsel to identify themselves and state who they represent for the record. They ask all the other persons to identify themselves for the record, including anyone who might be in the room with the witness. They add to the record anyone who joins late. They swear in the witness with the option of confirming with counsel before swearing the witness in that the remote oath has the same force and effect as if done in person, and reading in any stipulation agreed upon in advance with the taking attorney. They record the entry and exit of all parties unrelated to a lost connection. They stop the proceeding if anyone drops their connection so that no one misses any of the testimony. They do not handle exhibits. The entire focus of the court reporter should be on capturing the verbatim record. What are some of the ways the exhibits can be handled during the proceeding? Remember, the virtual environment does not lend itself to the court reporter handling exhibits. There is no way to slide the papers across the table. However, the process of sharing and distributing documents to others at the proceeding is pretty simple and straightforward. The counsel or the person so designated by the counsel can use the platform's share screen function to share new exhibits and give everyone a description of the document and its exhibit number. Another method I've seen is to distribute the documents and have everyone look at their own copies. This implies a standard format such as a PDF, but this can be done when you determine it should be done, not ahead of the deposition. The required formats of the exhibits depend on the video conference software you are using. The major brands will allow you to share any document you can view on your computer, not just a PDF, but also an X-ray, a spreadsheet, or a CAD/CAM drawing. However, for purposes of enabling others to view the files independently, and including those exhibits in the finished document, PDFs are a preferred format for distribution. Counsel should have the ability to give remote control of the document to the witness so that they can page through and annotate the document as requested and as needed. The counsel should be able to take back control, however, at any time. You should also be able to distribute copies of the exhibits to the other parties as if you were handing out paper copies. The way you do that will depend on the video conferencing platform you use. For example, in Zoom and WebEx, you can share the file with a very simple file transfer function, or you can use a third-party file sharing platform and grant access by copying or dragging a file from a private to a public folder. Note, though, that exhibits are not considered submitted to the court reporter until you actually send them to the reporter. After the deposition, All exhibits not previously sent to the reporter ahead of time should be sent immediately, following the methodology agreed upon with the agency. You have several options when it comes to the annotation of exhibits. If you're displaying a PDF, you can use the Acrobat comment tools to highlight, circle, or otherwise mark a document. The advantage of doing this is that first, you can do this ahead of time if you wish, if it fits your approach. Secondly, you will be actually marking the document and not just a single separate image file, which you need to send to the court reporter. However, you can use the annotation tools of the video conference soft platform and save an image of the marked up page and submit it as an exhibit to the court reporter. Become familiar with how the annotation tools work before the day of the deposition. For example, learn how to clear the marked up page. Otherwise, you will continue to see those annotations when you open the next document. The deposition is over. What does everyone do next? The court reporter confirms all orders and collects the witness's email address so that the witness can receive, review, and return the read and sign. The remote videographer, if one was present, will confirm orders and ask if the video should be synchronized to the transcript or unsynchronized. Note that the quality of the video will depend on the quality of the witness's webcam, audio, and bandwidth. If you haven't already submitted your exhibits, we recommend renaming the file name to include the exhibit number, then send the files to the agency using the process discussed with the agency beforehand. Make sure you understand the security of the platform used to transfer, access, store, and distribute the final transcript, exhibits, and video. Even though we're in a new, abnormal remote world, the model rules of professional conduct still applies. You have a duty to protect your client's information from inadvertent or unauthorized access. Once the court reporter has access to the documents, she will prepare them for the agency. Any questions about the exhibits should be between the court reporter and the firm contact. Finally, the court reporter transmits the final transcript to the agency, and after that, you will be notified as to the manner in which you can access your files. Finally, let's discuss security. The technology you use to hold depositions is very important, but security is about even more than just the technology platform itself. Implementing security controls are an even more important way to protect the proceeding. It is the simple slip-ups that can be exploited by others. Let me give you an example. Let's say that you have a Maserati and it's got a great security system. A Maserati left in the driveway with the keys in the ignition, doors unlocked, and windows down will not be your Maserati in the morning. But a Maserati parked in a locked garage with the windows up, the doors locked, and the alarm on stands a much better chance of being available to you the next day. So, with that in mind, ask your agency these questions. How familiar is the agency with the security controls of their video conference software? How long have they been using it? Is the meeting password protected? Can the one-to-one chat be turned off to prevent the witness from receiving assistance from another party? Can the video conference session be locked at the start of the proceeding? What is the security used to protect the documents stored? And how are the exhibits sent to the court reporter? All of these are important. So I want to say thank you very much for attending this webinar. We hope it was of value to you. And now I will turn it back over to Joyce. Joyce?
Great, thank you, Peter. Okay, before we look at some of the unanswered questions, I would like to offer anyone who'd like a copy of this webinar deck to send an email to discover@esquiresolutions.com. All right, so let's see what some of the unanswered questions are. Does your software allow you to split screen the exhibit and the deponent simultaneously? Sounds like a Peter question.
The answer is absolutely. Any video conference software should give the ability to see the witness on one side or in the corner and the document that's being shared.
Yeah, like right now I'm looking at the document and I'm also looking at Peter.
Great. There was another question about whether there will be a CLE for this course. A couple people from our office inquired about it. We do have this approved as a CLE in the state of Florida, and we are now actually applying for it in a number of other states. So we will put that information on our website, www.esquiresolutions.com, when we do receive accreditation in other states outside of Florida. Will the webinar be replayed, and will you be providing a copy of this webinar or a copy of the slideshow? Yes, again, if you would like a copy of the webinar, send an email to discover@esquiresolutions.com. Let's see if there's any other. Can more than one attendant be recording the conference at one time? That's a technical question. Over to you, Peter.
The answer to that would be no.
Very good. Does the final video show the deponent and exhibit when an exhibit is up? That's a Peter question.
The answer to that is yes. If that is something, I'm a man of few words. If this is something that you've requested ahead of time, ask that you would like to have picture-in-picture, and then we will discuss how to get that done. Absolutely.
And that's the process that we employ. Where,
of course, you need to check with your agency to see if they can do it, but I'm pretty much familiar with the others, and they should be able to do that as well. But do ask them; they may not be able to.
There's a question in the chat feature, since we have a few minutes. Have courts allowed private court reporting companies to conduct court hearings when court is not able to provide this type of technology? I have seen that, but you would have to work with the court itself to make sure that that's okay to do. Courts have specific security requirements, and you would want to make sure that whatever the agency you're using can comply with those. So that's just something to talk about with the court administrator in that particular jurisdiction. There's a similar, not a similar question, but a question of whether we can use a recording of a video conference in court, or do you need to have a separate videographer? And as those of you who've gone to law school know, the answer to most questions is it depends. That answer is it depends. It depends on the jurisdiction. Some jurisdictions have certain requirements that are necessary to have an admissible video. Other jurisdictions, you can bring an iPhone and record it that way. And you can admit it. It all depends on the jurisdiction involved and then the particular rules related to that jurisdiction.
if you do have a question, instead of raising your hand, if you would please put your question in the Q&A. Repeating again how to request the PowerPoint, send an email to discover@esquiresolutions.com, the email address that's up on the screen. This looks like an Avi question regarding non-party witnesses, especially one who is not cooperative. Do you have suggestions on subpoena verbiage to compel video presence of the witness?
I mean, I don't have, again, disclaimer, all jurisdictions are different. I'm certainly not, I don't have all those jurisdictions memorized. I would suggest most of the rules permit, again, the parties to stipulate. So if you can get the party to stipulate as to particular language, but I would simply put in the subpoena that they require to appear via video technology and give the specifics. At the end of the day, that is one of the situations where you may actually have to go to court and have a court order it. But as we've seen from some of the early court orders, courts are willing and happy to order someone who is able to appear by remote technology.
Maya asked about getting one-on-one tutorials. Yes, we are doing that. Our client executives are all experts on giving one-on-one tutorials, and we encourage that with all of our clients. So if you know who your client executive is, Maya, send an email to them just asking for that. And if you do not know, send an email to discover@esquiresolutions.com and we'll find the right person for you. Let's see if I've missed any questions.
There's the question about if an attendant pushes their record button during the conference, will it stop the court reporter recording? And the answer to that is only the host can stop and start recordings. Peter can correct me if I'm wrong. So not everybody will have the ability to start and stop recordings. And now, of course, again, I should say, everything depends on how it's set up to begin with. If you're working through us, that's the way it works. Peter, did I get that right?
That's correct. No, you got it right.
I can be taught. And then the last question, we get this one often. If you subpoena a non-party and they do not have technology, can they be ordered to go to the reporter's office? Again, that's going to all depend on what current essential versus non-essential situations are happening within your given jurisdiction. Certainly under normal times, they could be ordered to go a particular place to have a deposition. During these times, it's going to be hard and tricky to try to get somebody ordered to do that. So that's one of those things that makes it hard. There are ways to get technology to people or to have people go to offices to facilitate it, but in this day and age, it's just kind of a challenging situation. We're all just trying to figure out the best way through.
Okay, we are after 1 o'clock, so I want to thank everybody for joining us today. We really liked having you here. Again, if you have a question that wasn't answered, email discover@esquiresolutions.com. And if you'd like a copy of this webinar, email that same address again. Thank you, everyone. Have a great day.